Hello again, my lawyer friends. One of the most important things in an attorney-client relationship is good communication. But good communication means different things to different people. So how do you define it in a lawyer-client relationship? Some types of cases require a lot of client input. Others don't require much at all. And some clients want to be involved in every aspect of the case, while others hired you because they didn't want to spend time and energy on their legal problem. It is up to you to strike the right balance between over and under communicating. But the rules of professional conduct do set a baseline for what level of communication is required. Today, I'm going to cover Rule 1.4, titled Communication with Clients. Keep watching to learn about your communication obligations, including the common scenario of having a protective order entered in a case. Rule 1.4a and b require you to communicate certain things. First, you must promptly inform your client of any decision or circumstance with respect to which disclosure or the client's informed consent is required by the rules or the State Bar Act. Second, you must reasonably consult with your client about the means by which to accomplish the client's objectives in the representation. Third, you must keep your client reasonably informed about significant developments, including promptly complying with reasonable requests for information and copies of significant documents when necessary. The word significant is key here. You do not have to communicate insignificant or irrelevant information. And whether a particular piece of information is significant or relevant depends on the surrounding facts and circumstances. And as the comments to the rule explain, you may provide copies of the documents electronically. Fourth, you must advise the client of any relevant limitation on your conduct if you know that the client expects you to do something that is not permitted by the rules of professional conduct or other law. Fifth, you must explain things to your client to the extent reasonably necessary to permit the client to make informed decisions. There are also some limitations on your obligations under Rule 1.4. Although the word promptly appears more than once in the rule, Rule 1.4c allows you to delay transmitting information if you reasonably believe your client would be likely to react in a way that may cause imminent harm to the client or others. But the comments note that this does not alter your obligations applicable upon termination. If you're a litigator, you might often enter into a stipulated protective order preventing you from disclosing certain confidential information. And it will often prohibit you from disclosing it to your client. Well, Rule 1.4d specifies that your ethical disclosure obligations are subject to any protective order, non-disclosure agreement, or other legal limitation. So the protective order comes first. And lastly, the comments make clear that this rule does not create, augment, diminish, or eliminate any application of the work product rule. So your obligation to provide work product to your client is governed by other law. That covers Rule 1.4. Don't forget to subscribe to my YouTube channel to get more free videos covering the rules of professional conduct and other advice that will help you in your legal career.